Good afternoon, everybody. Welcome to the Innovation Law Club Africa Intellectual Property Law virtual panel discussion. I think a few attendees are still joining, but we're going to kick off right now. The theme for today's discussion is intellectual property and computer-generated works, and it's an African discourse on the law and policy surrounding these issues. My name is Narushka Bowen. I'll be the moderator and facilitator for the discussion today. I am based in Johannesburg, South Africa. I have a background as working as a technology and privacy lawyer for an international law firm. And in the last few years, I've done a lot of education and awareness on the topics of emerging technology, legal tech, and technology law, both to lawyers and to other audiences. And I also do some consulting in the space as well. Joining me today is Dr. Ulrika Till. She is Director of Artificial Intelligence Policy at the World Intellectual Property Organization. We also have Kenneth Muhangi, the Managing Partner of KTA Advocates based in Uganda. We have Dr. Adekemi Omotubura, lecturer in the Faculty of Law at University of Lagos in Nigeria, and Richard Kaibanda. He's the Registrar General of Companies at the Rwanda Development Board. I'm actually going to let each of our panelists introduce themselves for a few minutes. They're going to tell us a little bit about the work that they do and how it ties into today's discussion. So I'm going to hand over now to you, Ulrika, if that's okay.
Sure, thank you for the introduction and hello everyone. My name is Ulrika Till. I'm the Director of AI Policy at WIPO, the World Intellectual Property Organization. I have a background in technology. I have a PhD in physical chemistry, as well as a legal degree, having practiced as a lawyer and partner in a law firm in the UK and Germany. And I have a background in the pharmaceutical industry. In my last role before joining WIPO, I headed the IP team of one of the largest generic pharmaceutical companies in the world. What keeps me busy at the moment is AI, and there really is a question with computer implemented inventions. Is AI the same as computer implemented inventions? Is it different? Should it be treated differently? And what keeps me very busy is that WIPO started at the end of last year a process consulting about IP aspects, IP policy aspects arising from AI as a technology across all areas of our life. That is going into a conversation, a second session in July, on July 7 to 9 in a virtual way in 3 weeks' time. So that keeps me super, super busy at the moment.
Thank you so much.
Sure.
Kenneth, if we can move on to you, please.
Yes, sure. Thank you very much, Narushka. Good evening, everyone. My name is Kenneth Muhangi. As introduced, I'm the managing partner at KTA Advocates, which is a fully specialized technology, media, telecommunications, and intellectual property law firm in Kampala, Uganda. I lecture at Uganda Christian University, where I teach intellectual property and cyber law. I also give guest lectures at Makerere University. I represent Uganda at the Center for the Fourth Industrial Revolution at the World Economic Forum. My portfolio is drones, but I still advise on all other aspects of the 4IR. I also consult for the World Bank, also for drones in this particular region. And I also advise our Ministry of ICT externally on innovation. So yeah, that's it.
Thank you so much. Richard, if we could jump over to you now. Richard, I think you're on mute. Okay.
Yes. Yeah, technology always teases us. Thank you very much, and good evening, everybody. As I said, I'm Richard Kaibanda. I'm the Registrar General at Rwanda Development Board. The Office of the Registrar General, which is a department within Rwanda Development Board, is in charge of registration of businesses and collaterals but also at the same time, it serves as the National Intellectual Property Office. So we deal with IP administration on a daily basis, and we suggest proposals for amendments where possible in terms of policy and legislation that pertain to IP matters. I guess that's all for the purpose of this session. Thank you.
Thank you, Richard. Kemi, over to you. Kemi, I think you're also on mute. Thank you.
Good evening, everyone. My name is Kemi Omotubura. I teach law at the University of Lagos. So I teach IT law, IP law, and banking law, and also practice as a lawyer in Nigeria, called to the Nigerian bar. And so my background is in information technology law. I have a master's degree in cyber law and a PhD in cybersecurity law. So, and I've worked on a number of projects, yeah, on AI and IT and IP. So I'm looking forward to this session. Should be interesting. Thank you.
Thank you, Kemi. Welcome to all of our attendees who have joined. Just to let you know, there is a Q&A function that you will find on your Zoom panel. If you click the Q&A function, you can ask questions at any time throughout this panel discussion, and the panelists will be able to see it. During the discussion, I will be looking at the Q&A and selecting some of those questions from there. So if you hear anything interesting that you'd like to hear more about, or any questions, please do ask that at any time in the Q&A section. There's also a chat function, but if you can try to put the questions rather in the Q&A, that would assist. But we will also try and check your comments in the chat as well. Okay, so to kick off, Kemi, I'm actually going to come straight back to you. Could you actually help us first with some terminology before we get going, because we may not be all experts in these areas that are on this call. So our topic today is intellectual property and computer generated work. So what do we mean when we say intellectual property and intellectual property law? And what do we mean when we say computer generated works? If you could just help explain those terms before we kick off.
Okay, so thank you very much. So we know that intellectual property rights are these rights that are granted to inventors, to authors, to works of creativity, essentially. And they are rights given to persons over creations of the mind. And when we talk of examples, like we know, there are copyright, patent, trademarks are all examples of IP right, trade secrets, rights that protect confidential information are all examples of IP rights. So when we talk of computer generated works, and that's exactly what, I was hoping that I would be able to address at the beginning, because I think that we are talking or speaking about a concept that we're not really clear about. So I think is it Ulrike? Did I pronounce that right?
Ulrike, yeah, that's right.
Yes, yes. So because you did mention at the beginning that, look, what are the distinctions between computer generated works and artificial intelligence? So we talk about AI generated works, autonomous artificial intelligence, work generated by autonomous artificial intelligence. And what are really the clear distinctions? We talk about computer-assisted works. So we really need to be sure, and that's why I said that I'm not disposed to giving a definition of computer-generated works, because I don't believe that we have really an agreed definition of this concept. Because if you look, there are jurisdictions that have defined that as, you know, work that is absolutely independent of human intervention, which are generated mainly by computers. But you know, there are a lot of ethical issues surrounding whether computers can actually do that. And then how does that, when we say computer-generated works, are we also including AI-generated works? So I'll say that that's still largely a very vague terminology, you know, that we're trying to work around. And, you know, we need to find explanations rather than try to define these terms. And I believe that as we go on, you know, in the discussion today, maybe we can have some consensus or some agreement on what actually amounts to computer-generated works. But, you know, for example, in Nigeria, there's no definition of computer-generated works. So, yeah.
No, I think what you're saying is so important, and especially with areas of law that are so new, so developing, so fast moving, to say, you know, we have this definition set in stone, you know, is maybe, you know, a bit naive. These things are developing all the time, and it's actually more of a fluid definition of what we have today, as opposed to something that we can say is set in stone. Ulrika, I don't know if you wanted to add to that discussion in terms of terminology, and maybe then, you know, carry that discussion further in terms of, you know, what the World Intellectual Property Organization has been doing from a policy perspective when it comes to AI. You know, have you had these discussions and these debates around terminology, you know, in your consultation process? You know, so do you have any further comments on that point?
I mean, it's a huge open question, right? Because I think when you go back, I mean, obviously, I mean, I go back to TRIPS Article 27, that says you can have exceptions to patents if you look at the patent field. And it has meant in some countries mathematical methods are not patentable, which has meant that when you look at software, there really is a disparity across the world whether software per se can be patented or cannot be patented. And the concept of computer implemented inventions really came from the fact that even if you can't patent methodologies, mathematicals or software, if that ends up in an innovation, a method that runs on a computer program that does something new, you end up with a patented invention. In the past, that clearly has meant that computer software has been a tool used by humans. Now the question becomes very much, is AI different? So is AI something that, and we'll get onto it later, the European cases from the EPO, can AI be an inventor? Can AI be a creator? Is it autonomous? And really, I think we need an understanding of how AI works. I always think law doesn't operate in a vacuum. Law operates on facts, and in some ways we have a deficiency of understanding on facts of the technology underneath, which makes it even harder to find the definitions. But it's also, and apologies if I'm jumping around, but I think it's a concept when you look at it like I do from a policy perspective that is really important. If you treat AI simply like a computer implemented invention or computer implemented work, you narrow the question that you're looking at and the potential legal answer significantly. I'd like to take a step back, and that is really what we're trying to do with the conversation on IP and AI at WIPO, because when you look at AI intrinsically has three elements. And there is a lot of discussion at the moment of the output of AI, the AI-generated works or AI-generated patents, and are they patentable? Do they benefit from copyright or don't they? But I think we mustn't forget there are two other elements in the equation. The second element is the AI algorithm itself. And then that really becomes a question of can computer programs, can the AI algorithm be patented? Can it be protected? Should it be protected? What do you do because the legal provisions around the world are so different? And then the third bucket, which I think is an even bigger bucket for me, is AI is taking off, and AI is only being able to do what it can do because of the availability of curated training data. And that's not just big data, that is actually data that is labeled, that investment goes into, that is used to train the AI to do the things it can do. And then you run into that third big bucket of what are the rights in data? Should there be rights in data? And how does that interact if there aren't rights in data with trade secrets? Is it a good thing that trade secrets might be used? So, and I know this is a very long introduction from my side, but I think it's really important to AI certainly is very similar in some ways and has overlaps with computer implemented inventions. But I'd like to think of it as there's much wider issues that all interrelate.
Thank you for that, Ulrika. Kenneth, you look very eager to share some views. So I want to jump over to you now. And from your experience, I mean, we've obviously discussed, you know, defining these things are not that simple, but from your experience in terms of what are some of the challenges that we've seen when we do try to apply intellectual property laws to computer generated works? You know, what are these challenges and issues that arise? And, you know, what solutions do we have to these problems? You know, do we have ideas to close that gap? Because there's so many areas of law where, you know, tech seems to be streaming ahead and the law almost is pulling us back. So do we have that issue in IP law, or do you think we have adequate IP laws in your jurisdiction and in your experience of other jurisdictions?
All right, thank you, Narushka. I think first, I just wanted to just add on to what Kemi had mentioned about not having one general definition for computer-generated works, which I agree with, because I actually believe that artificial intelligence falls within the definition of what a computer-generated work is. If we go to the foundations in terms of the building blocks of AI, it's code. And as Dr. Ulrika said, of course, there's a discussion all over the world as to whether we should patent or copyright software. My view is, well, in Uganda at the moment, currently, it's a little bit of both. We're trying to look at, for some software applications that have or that meet the considerations, we do get utility mode applications. So that in our jurisdiction has been the middle ground. But generally, to answer your question in particular, as to the challenges or how people are receiving AI and other computer generated works, I would think, of course, the biggest thing that, so the internet has been a bringer for good, but also for bad. And of course, one of the biggest things is infringement. On top of connecting the world, it's also made it very easy for people to copy and people to infringe. And I know, for example, that the European Union, was it last year, decided to sit down and come up with a specific directive on computer generated works, especially in regards to copyright. And of course, there was a lot of furor in regards as to whether things like memes should fall under that particular category. So I'd be curious also to know what Dr. Ulrika has to say about that. But in my view, I'm glad at least that memes and the rest were excluded from such from the ambit of that particular directive. And of course, in terms of defamation as well, online defamation. You have a lot of notice and takedown requests on that part, but on the part of IP as well, you have issues that relate to trademark infringement that also require notice and takedown requests, because one of the biggest problems that the internet has brought is anonymity. And it's very easy for someone, say, to set up an account online and sell Philips products or any of the popular brands. And essentially, you'd never know exactly who the person is. So what we have in our legal framework or in our legal parlance is a Norwich Pharmaco order, which is very popular all over the world, but mostly in terms of unearthing perpetrators of online defamation, but it may also be used in cases of trademark infringement. And then, of course, I think the most interesting one is when it comes to cultural heritage. We know that recently we've seen an upsurge of museums and countries trying to preserve cultural heritage, and in particular, trying to preserve works of art. I know that last year we were fortunate enough to be, I think, the second country in the world, or the second African country to host an exhibition of Leonardo da Vinci. But the whole exhibit was a digital art exhibit. So then, but of course, this was hosted by the Italian embassy. And as we all know now, Leonardo da Vinci and his art now really form part of cultural heritage. If you think about Leonardo da Vinci, you think about Italy. So, but that also brings other problems, especially now that we're looking at things like repatriation requests from countries saying, bring back horses perhaps that were taken a while ago. I know there are countries like Chile, Zambia as well, even Tanzania has given repatriation requests to the UK Museum to be able to bring back their fossils. So if those particular fossils or works of art are scanned, who owns the intellectual property in that? Is there a new intellectual property right that is created? So those, I think, those are some of the major issues with that. And then lastly, perhaps I'll also say in terms of intermediary liability, I mentioned before that we have a lot of infringement online. So with that, of course, we know that internationally, most countries, their laws exclude or limit liability for intermediaries. And in certain instances, of course, sometimes the actual product owners find a hard time trying to take down certain items that infringe on their IP. So I think those, in my view, are some of the issues that arise from computer-generated works.
Sure, no, I think all of those extremely important. I'm going to pull Richard into the conversation now. Richard, you know, we've seen artificial intelligence, AI, computer-generated works kind of boom on a global scale. And you know, with that, do we have the counteracting in terms of policy to go with that boom in AI? So do we have any existing policies on the continent or in your region that you think are adequate to deal with this emergence? Are there talks behind the scenes for these laws to come into force? You know, do you have any insight into how the laws are dealing with this emergence of AI?
Yeah, thank you very much. As you said, indeed, AI and IP has inevitably become a subject of discussion on different fora. And this is a result of AI continuing to advance for the past few decades. But while most African countries have put in place general policies and regulations on AI as a whole, or are in the process of putting in place AI-related policies, it is important to underline that most countries have not yet put in place policies that indeed address IP issues that surround artificial intelligence. We may say, for example, that in most IP jurisdictions, it is recognized that inventions that are devised through a computer-generated or a computer-assisted system are not capable of patent protection. If you look at most laws that we have and policies that are around them, they are premised on this traditional concept that IP, in principle, results of human intellect or human creativity or inventiveness. So you will find that in most jurisdictions in Africa, even where you will find that companies are applying for patents, for instance, it will be a requirement to name an inventor who is behind a given innovation. So this indicates how our laws and policies are really premised on the traditional principles linking innovation and creativity with the human mind. This is also the case in copyright laws. Like if you look at our laws, like if I may talk of the Rwandan law, you will find that even if the inventor or the creator is not defined expressly as a human being, but if you look at other laws that we have and the principles that are in those laws, you will find that only human beings, that is natural persons or legal persons, can only be subjects of law. This is, they can only enjoy rights and can be subjects to obligations. So this makes it a bit difficult for our laws and policies to respond to the current emerging new technologies, including AI and the like, or the associated. But I may say that even if there is no concerted effort at the continent level or the region level, we have started seeing some interventions, some discussions that are putting together some countries to discuss these emerging technologies, how they can be regulated, how they can be legally recognized. So if I talk of the case of Rwanda, for instance, we are now having a number of policy and legal instruments that are being developed in efforts to see how these new technologies, the AI, can be regulated. For instance, we have a draft AI ethical guidelines. These are meant to set ethical principles from which AI systems can be assessed, whether it is at the time of the design, development, and deployment, to ensure that these AI systems are trustable, that is, in terms of the technologies themselves, or the way they are built, or the way they are used by humans. We are also having draft regulations on personal use of data. It is important to highlight that technologies like AI are built or feed on data. So it is important to regulate data. And we are having a draft regulation on personal use of data. We are also having a draft law on data protection. These are indications that even if we don't have currently a policy or a regulation or a regulatory framework in place, AI is gaining momentum, and as countries, we have to follow suit and start revising our legal instruments and policy instruments to address challenges that are coming with the AI and other emerging technologies.
Thank you, Richard. Thank you, Richard. Kenneth, I think
yes. I just wanted to add just something really small. One of my favorite authors is Chinua Achebe, and he says that tales of the hunt always glorify the hunter rather than the prey. So I just wanted to just add a little bit onto what Mr. Kayibanda had mentioned. As he mentioned, I think in the region we don't, our laws perhaps do not expressly mention AI, but it's important as well to let the world know that yes, East Africa is ahead when it comes to intellectual property, when it comes to technology. I know for a fact, I was fortunate last year, we had a meeting with other East African states That is through the East African Science and Technology Commission, where we met in Nairobi, I think, last year. And we discussed or came up with an East African policy on innovation. I know that as the African Union, we have, of course, the African Union Convention on Cybersecurity and Personal Data Protection, as Richard rightly mentioned, and as also Dr. Rick also mentioned, data protection is a very big issue. So that one addresses that. And of course, in Uganda as well, we have the National IP Policy, which specifically mentions technology and really shows that government's approach towards technology is changing. Burundi has a national policy for scientific research and technology innovation that was passed in 2011. Kenya has a draft STI policy. Rwanda also has an STI policy, I think passed in 2015. You also have one in Tanzania by the Ministry of Education and Sports. And in particular, our East Africa Common Market Protocol, for those of you that are listening, perhaps that are not from East Africa, we have an East African community which would like a protocol. And if you look at Article 42, it's on research and technological development, and it says that each partner state will commit to the promotion of research and technology. You have Article 43, which talks about cooperation on IP, which also says that all partner states will cooperate on IP. And then, of course, Article 44 that talks about cooperation on industrial development, which also really mentions tech. And if you look at that particular policy, that it's really anchored on pillars of regional integration, ICT, innovation, and the rest. So I really think that in terms of progress as a country, first of all, and as a region, I think we're okay, because even in terms of forming ministries, each country, Burundi has a Ministry of Science and Technology, Kenya has one as well, Rwanda has one, South Sudan has one, Uganda has two, the Ministry of ICT and Ministry of STI. And in Uganda in particular, if you look at a national budget, for example, this year, which was read out by a president just a few days ago, ICT is one of the sectors that they're really looking at. So I really just wanted to give a little perspective and to show that we are part of the discussion on AI and on IP worldwide. I just wanted to add that. Thank you.
No, thanks so much, Kenneth. I think very, very interesting developments. Kemi, I don't know if you want to just add from your region in terms of any existing frameworks, policies, laws that you think may adequately deal with the issues we're discussing today, or that are in the works to adequately deal with the discussion, what we're discussing today.
Thank you very much. Of course, in Nigeria, like Richard has said, in Africa generally, so development is, in terms of IT law, is moving forward, and government are passing, policies, they're making policies and passing laws. But, I also don't want us to lose sight of a point which is very important. That is that in terms of computer-generated works, and if we like, we can add, AI-generated work to make the conversation, broader. I want to say that I think that we're also missing an important area of this discussion. We tend to focus on the law, whereas most of the questions we frame as legal questions are actually ethical questions, which, whether we like it or not, are going to prop up at some time. Whether we make laws or we don't make laws, these questions are going to be asked. So, for example, for computer-generated works in some jurisdictions, some industry, with some inventors, we are being told that, we should allow computers to be inventors. We should give them the rights, intellectual property rights. But, ethicists are going to ask you, why should that be? Are they equal to humans, for example? So I know that the WIPO had this conversation, which was in December 2019, I believe, on IP and AI. And, you know, it was interesting that they actually framed the question, I think, what I would call human versus humanoid. You know, if we give them rights, then does it mean that we are placing computer creativity above human dignity? If we don't give them rights, are we sort of saying that, you know, human dignity, creativity is far more important than any other? So I think that these are conversations that are becoming really marginal in this race to, you know, we want to develop policies, we want to be sure that, you know, we are right up there, we are part of it. We are really ignoring the important questions that we ought to be asking and which policies need to be addressing. And something else that I want to point out is also that, you know, we need to reevaluate the role of Africa in the global discussions around these issues. So we also tend to play a marginal role in all of these, and, you know, other countries, other continents make decisions that affect Africa and Africans without Africans actually having a seat on the table. Or if we do have a seat, seats that have been given to us, we are not actually making this important contribution. So we might end up just borrowing policies from elsewhere and say, oh, because it exists somewhere, that is good, or it has been made by some international organization, oh, that is good, and, you know, we can just take this policy because it's what everybody is doing. So it's important that we have this conversation and not just throw policies and laws out there, you know. So, you know, having said that, I know that the African, this is the ARIPO, the African Region for Intellectual Property Organization, that it does have this model law which it has proposed. Not that, I mean, to the best of my knowledge, this law did not make any fundamental changes, you know, to the existing, you know, ownership, authorship, and so on approach that we already have. So, like I said, I believe it's because the conversation is not robust enough. In Nigeria, we had a copyright bill, you know, which would have addressed some of these issues, but more or less it stayed on track as to how you treat computer-generated works. So, I mean, if that's okay, I would say that I am not completely comfortable with where Africa as, you know, developing continent, developing countries. I'm not really comfortable with where we are in terms of the conversation that we are having in this area. I think it needs to be more robust and it needs to be far more encompassing.
Thank you for that, Kemi. And I just want to go back to a point you made early on that truly fascinates me, and that's this issue of giving rights to artificially intelligent, you know, computer-generated works or artificially intelligent beings. You know, if you think about the realm of robotics, for example, I don't know if anybody's ever watched the YouTube video of robots being assaulted. So people actually beating up a robot, and there's something inside of you as a human that makes you feel like this is not okay. Of course, you know, it's a robot, it's not a human being, it can't feel, it doesn't have emotion, but it still feels like it's not okay. And if it feels like it's not okay, does that mean we need to develop to a point where these type of AI beings get some kind of human right type you know, of rights, not human rights, but maybe AI rights? You know, are we moving in that type of way? But then the other side of the coin, if we want to give AI rights, then should we also give AI liabilities? Okay, you can't have one without the other. The two seem to go together when we talk about responsibility. So if we look in other areas of law, for example, there was a factory in Germany where there was a large robotic arm, also, powered by AI in the background, and this robotic arm malfunctioned and hit a human co-worker, and that human co-worker then passed away. But now, who is liable for the death of that human co-worker? Is it this robotic arm in this factory, which is building large equipment, or is it the owner of that robotic arm, or is it the employer of that robotic arm? And it actually came down to something in employment law, like almost like vicarious liability, where the employer is vicariously liable for the actions of its employees. A very similar type of concept arose in that scenario. So now we're seeing these type of beings more and more involved in policing, in terms of security. You have kind of robotics entering the spaces of humans, and where does liability sit? Now, when we bring liability back to intellectual property, now we can talk about intellectual property infringement. So now if we have an AI or a computer which is generating IP works, whether it be software code, whether it be art, whether it be music, books, I mean, anything is really possible when we're looking at this type of technology. But what if that new work is actually infringing somebody else's right? Now we come into this realm of liability. Should we then ascribe liability to computer generated works for these infringements? Ulrika, I don't know if you have any thoughts on this question.
Many thoughts, many questions. I'm not sure how many answers I can give, because that's really at the heart of the discussion that we have. I'd probably say you need to look at it from two sides. Obviously, should AI have a legal personality, should you assign rights to it, you then have to start asking who owns the rights, and with ownership of rights is liability. So if you said an AI generated work, the author is actually the developer of the AI software, then in some ways liability flows from that. But I think when you look at it from that side, you have to look at if you have rights, who owns the right, and then the causation of the liability with it. I probably want to take a step back, because I know an awful lot of the discussion is about details like liability. It's about details like, can it be a person? Can it not be a person? It's about, is it a software program? Is it not a software program? And really for me, and I come from it from a policy point of view, that the point of IP and a balanced IP system is to foster innovation. Now, if we want to foster innovation, and if we want to foster innovation the right way, I think you then have to ask, how do you set, and it's a policy for government point of view, how do you set the incentives to foster innovation in the way that you want to go? And this is why I come back to needing to think, and it's really, really difficult. I mean, my brain hurts every day and every week doing it, because it's almost, you get fascinated with one part of the discussion, like the case of, can AI be an inventor? What should happen? And that's really important, because the details are really important, because they're part of the jigsaw piece. But you can forget about the bigger picture. And I find I spend a lot of my time looking at details, but then having to step back at what the bigger picture is. And the bigger picture for me really is, what is the policy that we should be setting to foster innovation in the AI field? Because when you look at it from existing legislation, you could come, when I talk about the three buckets again, of data, the AI algorithm, the AI itself, and the output of AI, be an invention or copyright, you could very easily in some ways come to the conclusion that saying copyright requires a human creator, so therefore the output of an AI does not benefit from copyright. You then look at the AI algorithm itself and you say, well, that's software. It's a mathematical method of neutral learning. deep learning, that cannot be patented. You have no rights there. And then you look at the third bucket, and you have the bucket of data, which is very difficult because obviously there's data rights, there are privacy rights, there's all sorts of overlap. And you come to a conclusion, there really is no IP right in data. And you put the whole picture back together, and you end up in a system where there is no IP incentives at all in an AI system. And that might be the right answer or the wrong answer, but and I know I'm answering the question on a very specific point of liability by saying that's a really important point to look at, because of course it plays into each other. If you say, I don't want to have liability for an AI that I can't control, that I don't know where the liability lies and is responsible, that's a really important bit, but you also need to see it in the bigger system of what does then that mean for the entire IP system, looking at how you regulate AI.
No, thanks for that, Ulrika. Could you also just add in the story about the patent application that was made on behalf of a computer-generated work? I think it might just add a bit of context to have that example. If you could just explain a bit of that story.
So there were two applications for European patents, and there were parallel ones for UK patents, national patents at the same time, that were applied for, where the inventor was an AI. It did not name a human inventor. The European Patent Office first, and then UK later on separately, it fell down at the hurdle that the regulation in the EPC requires the naming of a human inventor. But they didn't even get to consider the details of it. They simply said the formality was a human inventor was required. There was none named. I believe from having talked to the patent attorney that was involved in it, the office actually asked, just put any name on there, just put a human name on it, but they clearly wanted to test the water. And at the moment it says a human is required, a person is required. That has gone to appeal. I think that was appealed last week or 10 days ago. But I think in some ways it highlights that, for historical reasons or not, and I think the reasons might be slightly different for patents and for copyrights, for creations and for inventions, but a lot of the legislation around the world requires a human author or a human inventor. So again, from a policy point of view, I mean, at that point you could very naturally fall out and say there is no IP right, there's no patent, there's no copyright on anything created by AI. But from a policy point of view, as I said, it's a question, is that an outcome that you want to sign up for? And I leave you with this I just throw this curveball in because I don't know what the answer to it is, because if you treat AI-generated works and human-generated works differently, and it's very difficult to tell the difference. I mean, I've looked at artwork created by an AI and by humans, and I defy anyone to tell the difference. But if you create those differently, treat them differently, how do you prevent people from not disclosing that something was created by AI in order to benefit from copyright, for example? So that there's a real, when you talk about the daily life of infringers and what you do in that case, you simply wouldn't know whether AI was involved or not.
Wow.
I don't know the answer to that one.
Kenneth, I think you have something to add to the discussion.
Oh God, so for me, this is like the part that I was really waiting for, because I really enjoy discussions in AI. So I wanted to answer the question in three ways. I hope you'll allow me just to take you on a journey. One, religion, and then science, and then law. So if we're looking at AI, first, I think my mom might be listening, just in case she is. I'll start with a quote, just so that I can save my neck. There's a philosopher that I really like called Francis Bacon. So he says that a little philosophy inclines a man's mind to atheism, but depth in philosophy brings a man's mind to religion. So Mom, if you're listening, don't take anything that I'm going to say. Anyway, so moving on. I think if we're looking at AI from the religious angle, so there's a premise called Imago Dei, which so many philosophers and people that are interested in religion have spoken about, which says we're made in the image of God. And it talks about image of God in regards to the characteristics of man or woman in regards to morality, ethics, basically the things that make us who we are. So if you ask yourself that question, will AI have those particular attributes if you're looking at it from the religious angle? Because I believe when we talk about AI, you can't really detach the discussion of AI from the other discussions around consciousness and around the future of our species. Because one of my favorite authors as well is Yuval, Noah Yuval, who I'm sure most of you have read as well. And he's really unequivocal in saying that, look, the future will have robots, will have AI playing a really big role. So as Dr. Ulrike said, should we keep quiet about such things now, or should we start having these discussions now so that when the time comes, we have the answers? Now, again, moving from religion to science as well, if you look at evolution, if you look at how the human being evolved, so of course, as I said, whether you look at it from the religious standpoint or from the scientific standpoint, ultimately we know that human beings are built from cells. Cells are our building block. Now, for artificial intelligence, the building block for AI is code, which is numbers. But of course, we know as well that with advancements in tech and with advancements in science, we've seen that AI has been given the ability to think on its own in certain instances. And that's why cases for things like deepfakes that Dr. Ulrike talked about, where you can't really tell a difference between a computer-generated image and one that's made by humans. So the concept of deepfakes is something that is, has taken the world by storm. There's a lot of people using deepfakes for revenge porn, for for memes, for committing a whole range of crimes. So here then begs the question: if you're looking at AI that can think on its own, that can create things, I talked about before how AI and evolution are together. Now, there is the new developments in the field of biology, that is CRISPR. I hope I'm not putting too much into this, but kind of just follow my line of it. Just give me a minute. So CRISPR is meant to, or is a new development in biology. It basically looks at gene editing. And so if you're looking at the people that perform the gene editing, or that extract strands of certain diseases or certain genes that are not desirable, you will find that human beings don't have the ability. Our hands here cannot be able to do that. So who does that? It's the machines. So you'll have a certain instance where these machines themselves are programmed to be able to look out for certain strands of disease on their own without any human interaction. So going back to philosophy, one of my other favorite philosophers is one called Jean-Paul Sartre. And according to him, he thinks that decisions are what make a man, or what make a woman. Choices are what do that. So if you look at his view of what being, of why we are alive, or why the Homo sapiens species is on Earth, and why choice is very important. Now, if you give choice also to one AI, doesn't that really give it the human attributes? So again, now moving to the last thing, where now we're looking at law. I believe that the law, in my view, is really the only way to be able to say, okay, look, let's have these discussions, but then let's be careful in saying, okay, is there a line that we can't cross? There's something called cognitive dissonance, where you have two conflicting worldviews, and that completely, shuts you down. And essentially, if you have that particular problem, you end up reverting to a choice that you're okay understanding. So of course, the other implications are, if later on, if AI evolves to a certain extent where it's now conscious, where it is self-aware, isn't that one of the attributes of a human being? So, and if that happened, if AI was then to become self-aware and was able to make choices, and at a certain point, if we then said, okay, AI has rights, as you were saying, if you romanticize the idea of AI or robots, and you then give them a human face, and you say, okay, maybe if you see someone beating a robot, perhaps they're beating a human being. Won't the discussion of slavery come back again? Because what happens later on if you find out, okay, AI has rights now, and then you say, okay, maybe all the people that owned AI, perhaps will there be any reparations for AI as well? So I think it's a really, really deep rabbit hole, but I definitely think that the law and regulation is the answer, in the sense that when we have these discussions now, and they're able to, to say that, look, you cannot hide from change. Change is inevitable. And the way AI is, essentially, it has made our lives easier. So I really can't see us going backwards, but I think we also need to be careful to say that, where do we stop as humans? Where do we stop, looking at it from the religious angle again? Are we then being God? Are these new beings going to take over the earth? I think that's what most biologists think, especially Yuval, as I mentioned. If you read any of his books, he thinks that the next race is definitely going to be run by AI. And I think you can also see, this is where I'll end on this part, in the sense that even now you see people using what do you call them, especially soldiers that have been injured and losing limbs. AI has been used to be able to recreate some of these limbs. So in terms of enhancing abilities, AI is going to play a really crucial element in that part. And also, lastly, in terms of regulating that and whether we should grant IP protection to AI, I think at this particular point, it's still too early to say yes, you should, because ultimately we haven't reached that level yet where we have any sort of AI that has reached that level of consciousness that you'd say, okay, are we dealing with a robot? Are we dealing with someone who is thinking? So until that happens, I would say that no. And especially in our jurisdiction as well, I don't think one legal framework allows that, but I also don't think in terms of religion, philosophy, and how far we have advanced, I don't think the discussion on whether we should allow AI to be able to create work, whether we should allow AI to own IP, in my view, I don't think that should be. I think we should just be able to distinguish in a sense for things like deepfakes and things created by human beings, but it is difficult to say that you can grant AI a human face.
Thank you, Kenneth. I mean, I agree with you. This topic is fascinating on so many levels, and and I like what you said. It's like falling down the rabbit hole. Once you start reading and exploring and delving deeper into these issues, you just want to consume more and more of that information because of how many questions there are. I think that's what Ulrika mentioned. There's actually more questions in the space right now than actually answers. But Richard, I'm going to come back to you now. And if your office had to receive a patent application, on behalf of an AI or a computer-generated work, how would that be received? Do you think such a patent could be registered in terms of the laws as it stands? Or do you think, legal definitions of what a person is first have to be expanded before we reach a stage of giving that computer-generated work this right? Or do you agree with Kenneth when he says, that AI is not even there yet where we can say it's good enough to be creating its own IP? So, what would you do if you received that patent application on behalf of a computer? Richard?
Okay, thank you very much. I definitely agree with Kenneth and the other interveners who say that this is a complex topic, and the debate are still at an early stage, if I may say so. But as Kenneth says, maybe we will reach a stage where AI or robots will be able to have this independent consciousness, if I may say so. But currently, if we look at the way the Rwandan law is, and I think this is the case for most laws, in light of cases, including those that you have cited, where attempts were made to name AI as the inventors. So Rwanda is no exception. If you look at the way our laws are drafted, they are drafted with that mindset. And legally, if I go into the strictly legal angle, it comes back to the other principle that only human beings and legal entities, legal persons can be subjects of rights and obligations. So definitely, if a patent well filed and a robot or an AI is named as an inventor, then it would not pass. But again, at the same time, I would underline that we should, at least at the moment, we should find a way of striking the right balance and not let this invention fall into public domain, because there is an investment that is being made, and we are all aware of the advantages that are being brought around by the advancement in AI and the similar technologies. And if we don't find a way of striking the right balance, then we would discourage these innovations, which we are benefiting from. We are having robots that are able, like if I talk about it in the current context of COVID-19, we've seen robots in China, we have them currently in Rwanda. They are able to perform some activities that would reduce human closeness or human intervention, and therefore reduce the chances of spreading the COVID-19. So these are advantages that are being brought about by the advancement in AI and similar technologies. So even if at the current stage we cannot recognize rights, including the right of authorship or inventorship to robots, then we should not also let them fall into public domain, but maybe try to find what is the right approach that we can adopt. Maybe look at who is behind, who has played a certain law in behind this AI, behind this robot, and maybe attribute the authorship or the invention to this person. But again, I'm aware that there might be another ethical perspective of whether this person is really or should really claim authorship of this invention or this creative work. So it's challenging, but again, we should find a way of striking the right balance. And again, I think as time evolves, we will reach a certain point where this discussion will definitely lead to recognizing, as Kenneth said, we may reach a certain point where we will definitely recognize some rights to these robots, to this AI. I think from the very beginning, we did not have rights recognized to legal persons, but as time evolved, these were recognized some rights, and I guess it's recent that in most it is a recent move that in some countries or most countries they are recognizing criminal liability to these legal persons, which was not traditionally there. So I think that at a certain point in time we will reach a stage where we might recognize maybe a certain bundle of rights and liabilities to these robots and AI or similar emerging technology.
Thank you so much, Richard, for that insight. Kemi, if we can come back to you now. I don't know if you have anything to add to this, interesting topic and discussion we're currently on, and just if you could also talk about whether you think, in order to cover all of these issues or gaps in the law, should existing traditional IP laws be kind of stretched or amended to include, these new models, or do you think this kind of deserves an entirely new framework for it to be approached with? What are your views in terms of that? Kemi, I think you're on mute. Okay.
Is that fine? Yeah.
That's fine.
Yeah. So thanks very much. I would say that in terms of whether we need to expand existing laws or whether we need to have what are called sui generis, I believe, protection regimes still need to be thoroughly evaluated. So we've, I think it was Richard, it was Kenneth who took us through, you know, this different dimensions of how we can view AI, you know, religious, philosophical, and so on. And I am of the view that until we actually have this in clear perspective in terms of, you know, whether we need to actually recognize these applications, AI and computers as separate entities, it will be difficult whether we want to extend existing laws or whether we want to, you know, create new regimes for protection. So I think a few months ago, it was the American Bar Association, I believe is the IP section, that responded to the US Patent and Trademarks Office. I believe it was called a request for response on artificial intelligence and IP or something like that. And, you know, the question was asked as to whether there should be new systems. Should there be sui generis system, or should the American law now accord recognition to AI, you know, as inventors, as authors of copyright work, as inventors in patent applications? And the answer from the association was, look, that's not going to happen for now. We don't believe that should be happening. They said, you know, no in principle to this because of the existing laws and the problems that are likely to arise. And they did argue, you know, central to that argument was you need to have, you know, general AIs. So AIs with general intelligence rather than those who are designed to perform specific tasks. So for example, what we have generally, AI can drive cars, so they can diagnose cancer, so they can take care of our elders, so they are carers and so on. But they can't do all of these things together. And what the argument is, you know, which I think Kenneth did mention, was until we have a system where we have AI with general intelligence, you know, then we should not actually be talking about assigning rights to AI. Now coming to developing countries like ours in context, I believe that, you know, like I said earlier, we need to be really careful because if I'll just check the name again. So yeah, it was Richard who mentioned COVID-19, right? So during this COVID-19, we've seen, you know, publications of free technical specifications, you know, that would otherwise be subject to rights. We've seen, you know, sharing of information on the technical specifications for tracking applications. And, you know, these are all things that would have been very difficult to achieve, for example, if IP rights have been assigned to AI. So, for example, will AI have the agency, the capacity, you know, to determine legal and moral questions about whether it's important to make information available, you know, to save people's lives? So, and we have to think seriously about that in the African context before we go the route of let's expand our laws or let's have a separate or a new system of protection, because we are in, delicate situation. We have more poor people, there's poverty, the health services are poor, and so on and so forth. So these are issues that we really need to put into consideration when we want to say, oh, should we expand our laws? Or, should we have new sets of, or a new kind of regime that protects IP rights? I think we should put it in context, because I was very happy when I saw, part of the discussion. We're not going to isolate Africa. We're not going to be an isolated continent. But then we need to share the baggage where, we just join the global conversation without actually thinking of the context in which these new policies or new laws would operate. So, my take on it is that before deciding to expand the law, which we have currently, and deciding whether new regimes are suitable, we should put all this in the context in which we are living and in which we are operating: social, political, legal, ethical, religious, if we like, and philosophical. All these dimensions need to be assessed so that we don't have laws. Because as you know, that's very common in Africa. We end up, having these laws that nobody actually implements, or that we then find that we can't implement because it doesn't suit our context. So I'll say, yes, we probably need to reevaluate the existing laws, but we need to put this in the context of the environment that we're operating in.
Thank you, Kemi. Interesting comment and question from Charlene received. So if we do give this new AI entity, if it does become the author of the IP, whether now or in the future, then, what are the other legal ramifications for that? So one example she shared is if the AI owns that IP, in normal contract law, if you want to transfer copyright or IP from one person to another, you would enter into a legal agreement, assigning that IP across, whether it's a software program or what, maybe a copyright in a book, whatever it is, but you do enter into some kind of legal agreement to do this. However, if the AI is the owner, does that mean now the AI will have full legal personality, even able to enter into legal agreements to assign that IP right? So these are the further questions that will obviously come along if we do give AI, the right of ownership over intellectual property. So I don't know if any of the panelists have thought about this question or have any further comments on this. You can just wave your hand and Kenneth, if you have a comment on this one.
Yes, I think I'll just answer it simply. Borrowing from company law, for example, companies have legal personality all over the world. Mm-hmm. And in this particular instance, legal personality allows you to own property, to sue, to be sued, into contractual obligations and the like. So if we limit that particular discussion in the legal sense, the same way a company is a body corporate. If you did give AI the ability to own property, I think that then opens the discussion to everything else, because essentially property, land is really one of our biggest curses, not only in Africa, but all over the world, in the sense that you have, I'm saying land is actually one of the biggest issues, not only in Africa, but all over the world. So if AI can own property, the same way a company can own intellectual property, I think what you're then giving it is legal personality to sue and be sued. So I think if we're limiting the discussion to law, then perhaps, yes, you may have a point. But again, going back to what we were saying, is the AI actually the one that has developed the actual product? If you're looking at that particular case that Dr. Ulrich mentioned, you're looking at AI that has been programmed to create things on its own. And then you're also looking at AI that creates something as a result of programming, in the sense that it's given a particular set of rules. Now, again, going back, if you understand code, I remember there was a situation a while ago in the US. I think it was in '93 or thereabout, where the 911 call system crashed. And the reason that was because of a coding error, in the sense that the coders at the time had put a limit, the maximum number of calls that someone can, that particular system can be able to take. When it reached that limit, the system crashed and it was down for a while. Now, if you're looking at that, really that particular instance shows you that it doesn't matter how you look at it. Currently, the human element is still very important, especially if AI is tied to coding. And as long as we're having a discussion from that particular perspective, I think the jury is still out on that one. But I'd also say that in most instances, seeking what is true is not seeking what is desirable. And in this particular instance, the truth is AI is most likely going to be able to make these choices and these decisions. So as I mentioned, in terms of legislation and regulation, we'd rather be proactive rather than reactive.
Thank you, Kenneth. And I think there was a further question about legal personality from Emmanuel, but I think your discussion kind of covered some of those queries as well. So I'm going to move on now. We're actually getting towards the end of our 90 minutes. Can you believe how fast that went, you know, when we're discussing these interesting questions? So I'm just going to jump now to our last question. And I'm going to open this one to all of the panelists. And what I'd like you to do is, in your 2 minutes, can answer the question and do your closing in the space of 2 minutes. That would be great. So I'm just going to frame the last question for you quickly. So we're talking about now the 5 large tech companies in the world. That's your Facebooks, your Apples, your Microsoft, Google, Amazon. And if we just think about the amount of information, the amount of data that each of these organizations are collecting from each of us every second of the day. I mean, to give an example, Facebook has enough user data to fill 400,000 Word documents. And Google has more than 7 times that. That's about 3 million Word documents per person. And they're collecting all sorts of information, things that you would not think would be important to them. So every time you click on something, if you click a like, if you send somebody a sticker or an emoji, they have that information recorded. If you delete documents, they also have that information recorded. It really is a surprising amount if you have a look at that. These same companies are also leaders when it comes to AI at the moment. And I mean, it's not a surprising to understand it. It's because of the amount of information they have. For example, Google alone is spending $433 million on its DeepMind AI initiative. And you know, AI becomes smarter because of all of this data that is available to it. Some of the counter arguments to it is that the data subjects whose data is actually being leveraged to train this AI should have some rights over the data that's being used. And there should be some kind of system where data subjects can kind of have ownership, control, and even monetize the data that is being used to train this AI. So, you know, given this scenario and how important data is for AI, do you think, you know, there's anything in intellectual property laws that will allow for a subset of rights in data, whether by the data subject or by these big tech companies, to enable, you know, the allocation of value to all the actors in the data value chain, the data subject, through to the company? And if we did design some kind of new rights, new data rights, you know, what would these new rights be based on? You know, does existing IP laws suffice, or is this something completely new that we're talking about? Is this now delving rather into data protection rather than IP law? You know, where really is the line? So if you can kind of share your view on this last question, and also give your closing comment in literally 2 minutes, I would really appreciate it, so we can come to an end in the next few minutes. Let's go to Richard to start. And Richard, I will have to stop you after 2 minutes, unfortunately, so that we can have enough time for everybody to have their say. So over to you, Richard. I think you're on mute, Richard.
Okay, yeah, thank you very much. In a few words, I may say that basically this data may be looked at in two possible angles. Either there is someone who is behind that information that these big companies are using, or this data that these big companies are using. So maybe we can look at, or people can start thinking of how the person behind it, the originator of this data, can be considered, whether it would be the expansion of the existing IP laws, or a sui generis system of law. But definitely, if these companies are using this data and there is someone who is the originator of this data, then this person should be recognized in the chain. Maybe the current laws and regulations on data protection may be inadequate, but at least I think in the current status of affairs, they can address some of these concerns rather better than IP laws that we have, depending for sure on the nature of the data that we might be referring to.
Sorry to cut you off. We are going to run out of time, so I have to just thank you there for your contribution and jump over to Kemi for her last thoughts. Kemi, you're on mute, I think.
Right.
Okay.
So, I would say that for me, there are two things that I would be looking at in this respect. So, because, you know, the broad agreement is that making data available, you know, is a good thing. So, you know, from a public good theory perspective, you probably want to evaluate, you know, whether it's going to help, you know, development, innovations that we're talking about when people are allowed to monetize the data or to commodify essentially the data that they have, because these data are used for learning, by learning algorithms. And, you know, like you sort of also mentioned an important point about, you know, the almost surreptitious collection of data. So if we don't know what data is actually being collected, how are we going to exercise the rights over the data, essentially? I don't know what Google knows about me, what Amazon, what information they collect about me. So how am I going to assert a right to that data when I don't even know, you know, what data is being collected? And, you know, the final point I'd like to make is about data protection laws and how they probably would provide maybe the best protection in this respect if they are properly framed to address these issues that, you know, you just mentioned. Thank you.
Thank you, Kemi, for that. Ulrika, if we could jump to you for your final thoughts.
Yes, difficult in 2 minutes, but I will try. I mean, this scenario for me goes right at the heart of the discussion that we need to be having, because you can see from those companies a couple of things. First one is data is hugely valuable to them. Data is what is driving the system. But also these companies and some of the leaders in AI are years ahead of law and of regulation. And the difficulty for me is IP laws are incredibly complex and intertwined, and it's very difficult to see if you make an adjustment here, what happens over there. But equally, we all have to be aware, while there is no regulation, facts will be established. I mean, the market will regulate itself, whether it's via contractual agreements, what people do with data, how it's being transferred. So I think at the end of the day, for me, it is absolutely crucial to have the discussion in order to fill the gap of understanding, fill the gap of the scenario and understanding AI and what's happening out there, because only then can we have a really helpful discussion on how the regulation should be. But I also think it's really important to have those discussions sooner than later and more detailed than possible, because the one thing that will not help us is not having the discussions until facts are established. And I'll leave you with one thought that is quite important for me when I think about AI. I think maybe there has to be a distinction that has to be made between what I call raw data, because data has been around and information has been around for a long time, and what I call curated training data, because the data that is used to train AI is not raw data. There's very often a substantial investment that goes into it in labeling the data in order to give it away, have it away, that the AI can actually understand it and train it. And maybe there has to be, I just leave you with a thought, is there a distinction between raw data where maybe there should be free flow of data, but the investment that goes into preparing the data in order to become usable, should it be protected? Does it have to be protected? What do you do there? Because at the end of the day, I think having the data in order to progress AI is the way how you get innovation. And I know I've probably outstayed my time, so I leave it there.
Thank you so much for that. Kenneth, your closing comments, please.
Yeah, thank you. I think first I'll say I totally agree with all the speakers. IP and tech really go well together. It's like looking at bread and butter. Alone, they're good, but together, they're less and more. So I think really you cannot separate IP and tech. And then moving forward, I think data protection was one of the countries that enforced privacy as a separate human right. And I think several other countries have followed. So I think all the examples you've given, those are all issues that we're facing. Privacy is a really big issue. And AI, as I mentioned before, is one of the tools that is used to be able to harvest this data. So in terms of some of the IP issues that arise from that I can think of, but things like database rights, we don't have database rights in our traditional legal parlance, but these are rights that exist and are recognized as IP rights. So this data that is collected in databases, who owns the rights to these databases, especially if you're dealing with personal data? Then you're also looking at things like image rights, because the data that is collected does not only collect personal identifiers, but also collects images and the right. So if Facebook or Google, these other companies harvest this data and harvest personal images, again, isn't there and there aspects of image right infringement? Then of course, generally, if you're looking at intellectual property and infringement, definitely with AI and especially with data, if the data is harvested, if you're looking at trademarks, for example, you can only use my trademark or my client's trademark if you have a license or if you've been given authority to be able to do it. So I think it is really important to understand that aspect. And perhaps in closing, I will just make an appeal to Dr. Ulrich Till. I know that there are working groups that have been set up all over the world to send issues on AI and IP. Uganda is among the countries that is about to get in touch with you. So I think the person on our end is a commissioner from our Ministry of Science and Tech, Patrick Mugisha. So if he does email you, please receive us properly. As you can see, we're really excited to share our views and to contribute to our discussions generally in the world. And perhaps especially also in terms of our society. I chair our ICT cluster of our Uganda Law Society. So I'm sure there are lots of lawyers as well that are online and that are listening, that are interested in these topics. So we should have more of these. So I just want to thank as well the organizers as well. Thank you for putting this together. Thank you.
Thank you so much, Kenneth. Just in closing, thank you so much to our panelists for sharing your knowledge and insights today. I've learned a lot, been fascinated by the discussion. Thank you for giving your time to share knowledge. I think this is how we, uplift and empower everyone on these very interesting topics. Thank you for our attendees for listening. Thank you for engaging. Thank you for your questions. I'm sorry we couldn't get to every single question. Just a lot to discuss. We could have continued for another few hours if you let us. Thank you very much to the Innovation Law Club Africa for setting up this discussion, for identifying the right people to be on this discussion. I think you've really outdone yourselves in terms of getting, the people who really are experts in this field to share the knowledge. For everybody online, if you want to learn more about Innovation Law Club Africa, you can visit the website www.ilca.africa. And they're also on all the social media platforms, so please go and find them and follow them. As you can see from this inaugural discussion, there's only going to be more and more exciting things to learn. So that is our discussion. Our 90 minutes is up. It really went by faster than I expected. Again, thank you to everybody for this discussion. We'll be logging off now. Goodbye.